and forfeiture fees to assistant public defender on behalf of Mr. Baudet. Please state your name for the record, sir.
Jason Baudet.
Okay.
This is where everything begins to tighten. A no-contest plea might sound like a technicality, but it's actually a strategic surrender without fully admitting guilt on record. The defendant isn't fighting the charge. He's stepping aside and letting the court move forward as if he already lost. And notice the charge: domestic violence, second offense. That second offense changes everything. It signals a pattern, not a one-time mistake. Courts treat repeat behavior far more seriously because it suggests escalation risk. Now listen closely to how the judge carefully walks him through his rights. This isn't just procedure, it's protection. The court must ensure that this decision is informed, voluntary, and free from pressure. If any part of that fails, the plea can collapse later. But right now, the defendant is saying yes to every question, calmly, almost mechanically. That alone raises a question: is this acceptance or resignation? And more importantly, if you were in this position, would you take the deal or fight it in court knowing the stakes just doubled?
Today is the date and time set for bench trial. At this time, the people are ready to proceed. The defendant will be pleading no contest as charged.
Thank you, Your Honor.
May I have the defendant sworn?
Right here. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
State your name.
Jason Edward Baudet.
All right. Sir, it is this court's understanding that you're going to plead no contest to the charge of domestic violence second offense. Is that correct?
Yes. Yes, sir.
That is a misdemeanor. It's punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. You understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
Two things I need you to understand about a no contest plea. The first thing you need to understand is that for purposes of is that it means that you're not desirous or wanting to contest these charges or this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. Understanding all of that, do you still wish to plead no contest?
Yes, sir.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial.
This is one of the most critical moments in any plea hearing. What you're hearing isn't just legal language, it's the dismantling of a defense before it even begins. The defendant is giving up the right to challenge evidence, cross-examine witnesses, and even present his own side in a full trial. That's massive. In a domestic violence case, witness testimony can be everything, especially if the situation involved conflicting stories or emotional escalation. By waiving these rights, he's essentially saying, I won't contest what's being said about me. Now, why would someone do that? Sometimes it's about minimizing damage, avoiding a harsher sentence if convicted at trial. Other times it's about pressure, fear, or even legal advice pushing toward a safer outcome. But here's the tension. The system ensures he understands what he's losing, but it doesn't question why he's choosing to lose it. That's where the human side of the case starts to creep in. Do you think he fully grasps the consequences here, or is he just trying to get through this moment as quickly as possible?
You're also giving up your right to be a witness for yourself or to remain silent and not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record, if anything, to get you to plead no contest?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
Court has been provided Pittsfield Township Department of Public Safety report for their case number 239033. Any objection to the court reviewing that report to form a factual basis?
Oh, Your Honor.
Based upon a review of that report, the court does find that there's sufficient factual basis. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
You have, Your Honor. You have, Your Honor.
Court will accept the defendant's plea of no contest to this charge.
Your Honor.
Yes.
For the record, that's because of potential civil liability.
Yeah, thank you, sir. I did not ask. All right.
That one line, potential civil liability, quietly introduces a whole second battlefield outside this courtroom. Even though this is a criminal case, the consequences don't stop here. A no contest plea can still be used in civil court, especially in cases involving harm or injury. That means the alleged victim could pursue damages separately, financially, not criminally. And that's often why attorneys advise no contest instead of a straight guilty plea. It creates a thin layer of separation, even though the court treats it the same for sentencing. What's fascinating here is how quickly that detail is acknowledged and then moved past. No long explanation, no pause, just a quick legal note and forward motion. But behind that, there's a much bigger implication. This case might not be ending anytime soon. It could simply be shifting arenas, and that raises a key question. Is this plea really about resolving the situation, or just containing the immediate consequences?
Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
August 21st at 1 p.m.
August 21st, 2023 at 1 p.m. That will be via Zoom. All right.
Thank you very much.
All right, thank you, sir.
Thank you,
Central Law.
sir. You can stop at probation on your way down the hallway to check in with them.
Okay.
All right. Thank you. Yes, on your left. Court calls the case, People versus Cassandra Wallach.
Ready, Judge Torsia, Feaster, Assistant Public Defender on behalf of Ms. Wolak, who is approaching the podium. Please state your name for the record, ma'am.
Cassandra Wallach.
Honor, today is the date and time set for bench trial. At this time, the people are ready to proceed. My understanding is that the defendant is going to be pleading guilty as charged under 769.48.
That is correct, Your Honor.
May I have her sworn?
I swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Cassandra Wallach.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. And understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Now the tone shifts, dramatically. Unlike the first defendant, Cassandra Wallach doesn't choose no contest. She goes straight to guilty. That's a direct admission, and it carries a different weight in court. There's no ambiguity here, no legal buffer. Just a clear acknowledgement of responsibility. But what makes this moment even more intense is how quickly it happens. The judge lays out the rights, the consequences, the penalties, and she still moves forward without hesitation. That kind of decisiveness can mean different things. It could be acceptance, remorse, or simply a calculated decision based on legal advice. And notice the charge, domestic violence again, but this time with a maximum of 93 days, significantly lower than the previous case. That tells you the severity or prior record might differ. Still, the emotional gravity doesn't change. A guilty plea locks in the narrative. It tells the court, this happened. The question now becomes, what led to that moment? And how will the court weigh intent versus circumstance?
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
I believe so.
Do you have any other cases?
No.
Okay. You're just on bond for this case.
For sure.
Sorry, Judge.
So that's a no.
That's a no, Judge.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No, sir.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
May 27, 2023, at the location of 2358 Twin Lakes Drive, apartment TA, Pittsfield Township, Washtenaw County, state of Michigan. What do you do on that date involving a Brody Salmon that makes you think that you're guilty?
Slapped him in the face.
And there it is. The moment where the case becomes real. Up until now, everything has been legal language, procedures, and rights. But this single sentence cuts through all of that. I slapped him in the face. It's simple, direct, and undeniable. The judge immediately follows up, confirming intent, context, and relationship, because in domestic violence cases, those details matter. This wasn't an accident. It wasn't unclear. It was intentional. During an argument involving a fiancé, that relationship factor elevates the seriousness because it falls squarely within domestic violence statutes. Now here's where it gets complex. The law treats physical contact as an offense, but human relationships are rarely that simple. Arguments escalate. Emotions take over. But the court doesn't operate on emotional nuance. It operates on actions and intent. And she admits both. So now the focus shifts from did it happen to what should the consequence be? Do you think the legal system handles these emotionally charged situations fairly, or does it strip away too much context in the process?
Okay, you guys were having an argument of some type?
Yes, sir.
All right, you did that on purpose?
Yes, Your Honor.
And so it was done intentionally and on purpose, and obviously you did not have his permission to do that, is that correct?
Yes, Your Honor.
What was your relationship with this individual?
He was my fiance.
All right. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Judge.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be August 21st.
Yes.
August 21st, 2023, 1 p.m. And that will be via Zoom. Okay? Young ladies, stop down the hallway. You'll see probation on your left and stop in with them, please. Thank you.
Our last one is in custody.
Hold on. Okay, last one's in custody. What are we doing on this one?
This is gonna be a no contest plea, Judge.
Okay.
And I did send the report to Ms. Wiley.
Oh.
Sorry, I had the rest of them printed.
Court does call the case of the People versus Edward LaRue.
Ready, Judge. Torshio Feaster, Assistant Public Defender, on behalf of Mr. LaRue, stand to my right at the podium. Please speak on the record.
Edward Robert LaRue. Okay.
The people are ready to proceed. The defendant is going to be pleading no contest as charged. The people have also agreed to work on a resolution of this upcoming felony witness interference case. The defendant has been contacting the victim consistently while on the no contact order and has called her as recently as yesterday.
This is where things escalate beyond the original charge. It's no longer just about domestic violence. It's about defiance of a court order. A no-contact order is not a suggestion. It's a strict legal boundary designed to protect the alleged victim. And according to the prosecution, the defendant didn't just cross that line once. He repeatedly ignored it, even contacting the victim as recently as yesterday. That's a serious problem in the eyes of the court. Why? Because it signals non-compliance and potential risk. Judges take violations like this personally, not emotionally but institutionally. It undermines the authority of the court itself. And now, there's a new consequence on the table: revoking phone privileges. That might sound minor, but in custody, communication is everything. Cutting that off is a direct response to misuse. This moment shifts the narrative from defendant facing charges to defendant ignoring boundaries. And that distinction can heavily influence sentencing. So ask yourself, is this behavior desperation or blatant disregard for the system?
The people are also going to ask that the court revoke the defendant's phone privileges.
Correct, Your Honor. I was made aware of that this morning. I told Mr. LaRue, he asked that the court is likely to revoke his phone privileges today, and he wants to resolve this matter, Your Honor.
Cameron Thorne.
Raise your right hand. You swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the true self you got?
I do.
State your name.
Edward Robert LaRue. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of domestic violence second offense. That is a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. Do you understand that?
I understand.
All right. Do you understand what a no contest plea is?
Yeah.
All right. First thing about it is that you need to understand it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Okay.
Okay. Do you have any other questions regarding a no contest plea?
No, sir.
Understanding all of that, do you still wish to plead that way?
Yes, Your Honor.
And to that charge, how do you plead?
No contest.
And you understand that by pleading no contest, you will not have a trial of any kind, sir.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything
No, Your Honor.
to this charge? Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, sir.
Court had been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 23-5059. Any objection to the court having reviewed that report?
No, Judge.
On a review of that report, the court does find that there's sufficient factual basis in which the court could determine the defendant's guilt of this offense, along with an acknowledgement of the previous conviction. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes.
You have, Judge.
Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
August 21st at 10 a.m.
August 21st, 2023 at 10 a.m. via Zoom at this time. Anything you want to say regarding bond?
I think they need a ruling on the phone calls and revoking his phone privileges, Your Honor.
I'm sorry.
I believe the people were requesting that you revoke his phone privileges.
Yeah.
He understands that likely, Your Honor, and he has no objection.
What do you have as current bonds in it? Yes, it's 10 cash, 30. That's what I've got here. Okay. In its monetary consent, the bond will continue. Defendant's phone privileges are hereby revoked.
And just like that, the court draws a firm line. The revocation of phone privileges is more than a restriction. It's a consequence tied directly to behavior. The defendant was warned, the rules were clear, and the court responded decisively when those rules were broken. Looking at the full picture, this case presents three different paths through the justice system. a no contest plea to manage risk, a guilty plea with direct admission, and a defendant whose actions continued even after legal boundaries were set. Judge Simpson maintains a consistent approach throughout, methodical, procedural, and focused on ensuring each defendant understands exactly what they're doing. No theatrics, no emotion, just structured accountability. The broader takeaway here is simple but powerful. The courtroom doesn't just judge past actions, as it evaluates ongoing behavior. Compliance matters just as much as the original offense. And in cases like this, every decision, from a plea to a phone call, shapes the outcome. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.